The whole topic on arbitration and the theme that has been given in this masterclass is a bit wide. And before we start, we just thought we will take a couple of people to just very briefly tell us what would they like us to talk about in this session. What we were really intending to do is talk for about 8 to 9 minutes each, talking about our experiences. I have not done commercial arbitration and I don't intend to do commercial arbitration. That's not my area of expertise. Rohan has a lot of experience on commercial arbitration and on tax arbitration. I will talk more from a policy standpoint, how things are shaping up, why has India taken the position that it has taken. But before I do any of that, very quickly, if there are at least a couple of people asking quick questions, PV, Neetu, whatever.
Sir, we understand the legal dispute resolution framework up to High Court, Supreme Court is law-based. Mutual agreement procedure can possibly travel beyond the law. Where is this tax sort of arbitration sitting? Is it wholly legal, partially legal, and partially this one? And what is the force of enforcement mechanism of that? That is kind of one I will have. Is there a framework which is being practiced globally, which other countries must adopt the efficiency of those practices? There's a concern on sovereignty, people say. What is the sovereignty concern, if you could address it? And likewise, it may travel beyond taxes to investments, if you could travel on that process, because investments and taxes are correlated economically. We can talk about that.
My question is, what are we going to cover today in arbitration? Are we going to cover tax treaty arbitration and the scope whether tax is covered within the treaty framework or not? Because we see, day in, day out, somebody sending notices to government of India and they are saying, no, sorry, tax is not covered. And the recent treaties, they are saying, India has taken a position. So I want some guidance on what is the India's current position on the treaty and whether tax is covered or not.
And good morning. Ajay from Minda Corporation. So normally when we talk of this international arbitration, suddenly it strikes in our mind that some dispute with a JD partner or some foreign resident. And normally lot of arbitration we heard in ICC or CAC and all. So this tax and commercial arbitration, these are the arbitration center who are taking for commercial and tax, and how it is different from the routine arbitration.
We intend covering some, if not all of the subjects, but Neetu, very quickly to your question, if the arbitration arises in Mumbai, then they should consult Rohan, and if it is Delhi, they should consult with me. You and I will have a separate conversation why it's expensive. Okay, so very quickly, what is the origin of tax arbitration? As we all know that there is a mutual agreement procedure under the treaty which tends to resolve disputes on treaty-related matters. There is a scope that has been laid down. Over the years, this scope has been sharpened as a result of explanations that have been given. The whole debate on mandatory arbitration started in somewhere in 2006. And in 2008, OECD adopted the mandatory arbitration approach. So if you look at the OECD Model Convention, which was amended in 2008, it said that mandatory arbitration is recommended. But as it happens, those recommendations are not binding on the OECD members as well. The first country really to raise the or sign up the arbitration was really initially Canada and United States. But Canada and United States was not, they started the discussion. The first two countries to sign mandatory arbitration were United States and Germany. And that in a way set in motion the debate on mandatory arbitration, because as you know, both the jurisdictions have very strong and very mature tax systems. Both of these jurisdictions believe in the right of sovereignty more than any other nation would believe in. And the world started reflecting, particularly the OECD member, that if Germany and United States, in particularly the United States, can deal with the sovereignty argument and still sign the mandatory arbitration. Why can't others? And then over a period of time, many people started signing it. Currently, we in the OECD club of 27 nations have almost, I think, 21 or 22, I'm not sure exactly about the figures. OECD and non-OECD nations, there are 29 that have embraced mandatory arbitration when they signed up for the multilateral instrument. Now, why mandatory arbitration? Simply because either your mutual agreement procedure has not been able to resolve a dispute, you are unable to stick to the basic intent of the treaty, which is avoidance of double taxation or economic double taxation, and hence arbitration. Now, how does arbitration happen? Unlike in a commercial arbitration, the most popular form of arbitration in tax is what is called a baseball arbitration. In a baseball arbitration, really the arbitrators really take the outcome that the two competent authorities have come out with, and they choose one. So really one is a loser, if you call it as a loser, and the one is a winner. In a baseball arbitration, the arbitrators do not really sit and walk the middle of the path approach. They choose one between the two. There are non-baseball arbitration, which is a normal arbitration, where the arbitrators sit and decide is also available. I'm not sure out of these 29 countries how many have opted for baseball arbitration, but the United States certainly has opted for baseball arbitration. This debate gathered momentum, even before the BEPS project. In 2011, when the OECD looked at revising the model convention, it did put out the debate of arbitration in obviously emerging markets and many countries who did not even have a mature map system to resolve disputes. Took a view that, let's at least get a map. For example, I was talking to one of the tax administrators in Vietnam 3 years back on a panel, and they said we have not done a single map in the country. Now, Vietnam is an emerging market. It's a huge jurisdiction. So, UN accepted the argument and said that yes, it is too early for United Nations countries to adopt mandatory arbitration. So they came out with what they call it as a alternative to mandatory arbitration, which was a mediation and conciliation process, and it is called largely non-binding arbitration. I do not think that the 2011 OECD UN recommendations or changes that they had proposed in the model convention really went anywhere. So the real debate on tax arbitration or mandatory arbitration picked up momentum only after BEPS. Now, why did it pick up momentum after BEPS? Because BEPS, in my view, is nothing but a weaponization through the action points of trying to bring to tax certain forms of income which are either not taxed under the existing treaty framework or under the domestic law of the source-based countries. And I think there was a huge debate in BEPS. So if there were two action points of BEPS, which in my view are utter disappointment, is action point 1, dealing with digital, and action point 14. Ironically, action point 14 is not a recommendation, it's a mandatory standard. So how does action point 14 become mandatory when you are leaving this to the country to decide whether they want to embrace arbitration or not? The argument advanced by people who drafted the multilateral instrument is that, well, action point 14 tends to improve the dispute resolution process. And there are ways and means to improve the dispute resolution process. One, by putting out a 3-year deadline to conclude on maps. 2, by convincing signatories to the MLI to have a bilateral APA so that you can avoid transfer pricing disputes. And 3, we really have left the choice to various countries to decide whether they want to or they don't want to. And most of the countries have come out with their points of view on why they should not embrace mandatory arbitration. India's view obviously has been the grounds of sovereignty. I have a fundamental disagreement with that point. And that disagreement is simply because if you look at the Constitution empowers the Union to enter into what they call international conventions. in my view, it is this power of the Constitution that is in a way delegated through Section 19, and then there is a delegation of power under Section 19 to enter into a double tax treaty. It's like trying to say that a union has a power to legislate a retrospective law, but it doesn't have a power to repeal a law retrospectively. It's as flawed argument as that. Another interesting aspect in our constitution is that, and I don't remember the article of the constitution, it says, India shall endeavor to resolve international disputes in a amicable fashion. Now, obviously, when these clauses of the constitution were drafted, what they had in their mind was if there is a dispute between two countries on sharing of river waters, or if there are border disputes, and not tax convention, because tax is even more fundamental sovereign right. I don't know whether that argument holds ground in today's environment. So I continue to believe that by not embracing mandatory arbitration, we are in a way, diluting our competitiveness as an investment destination. I hope over a period of time this argument will pick up steam. I do remember first time when we raised this, I was virtually thrown out of the room. I won't name the person who actually threw me out of the room, but I think at least there are people who are willing to at least debate that it's time for India to look at arbitration. So let me stop over here. I am mindful of the time that we have, and if we have time, I'll add some of my experiences on tax arbitration, but it will be good to hear from Rohan what his experiences are in tax, non-tax arbitration, particularly the BIPA-related arbitration, which has been doing the rounds and the news that you have talked about. Thanks.
Thanks, Mukesh, and thank you all for being here this morning. So let me pick up from where Mukesh talked about the process in terms of treaty arbitration and what's going to happen in terms of the BEPS. If we look at the BIPA, the situation is the primary function of a BIPA is to ensure protection of investment by foreigners in any host country. And we therefore have sort of evolved bilaterally a situation where we can negotiate BIPAs, and therefore the terms of each BIPA, very much like what you might see in trade agreements, can tend to vary from agreement to agreement. Right? The situation that you have within this is, what is it that causes you to be able to actually trigger a BIPA? Now, there will be issues in terms of the two basic situations you must address. A, are you an eligible investor? And B, is it an eligible investment? Let's say you get over the factor that yes, you are an eligible investor and it is an eligible investment. What typically will we see as cause of action and arguments back and forth? So if I look at the BIPAs which are around and the BIPAs that one is involved with, typically a claimant is going to premise his BIPA claim, especially in tax, on two situations. One, what we call the just and fair treatment, or what we would effectively call the fair and equitable treatment clause. So in terms of the fair and equitable treatment clause, you would say that I have not been fair and equitably treated by the host country. The other concept which would effectively come up is that if the nature of action which is taken by the host country is a tax provision which effectively wrongly denies or seeks to recover from an investor tax, then you would go in for a claim which is to say that there has been expropriation. So the typical claimant will say not fair and equitable treatment, and he will say this is an action which is expropriatory. Different nations will set up different arguments when you effectively talk of this, but let's see what the Indian position is. So the Indian position has always been threefold. The first situation is India will claim and always claim that any tax issue is not capable of being dealt with in a BIPA arbitration, which is always taken as one of our preliminary objections. that you cannot effectively take this up. Now, when we take this as a ground, the typical situation we are talking about is to say that when we talk of fair and equitable, when we talk of expropriatory, there must be a necessary exception. And that necessary exception is the exercise of sovereign rights and sovereign powers. And if you talk of sovereign rights and sovereign powers, they will basically be in two tranches. A sovereign right in the policy realm, a sovereign right in the legislative realm. But in certain instances, there will be a complaint in terms of interpretation and administration. So if, for example, we take a retrospective amendment, what is the argument by the claimant? Claimant will say this is expropriatory for the reason that a concluded contract by a retrospective amendment is sought to be taxed, and to the extent that you retrospectively are trying to tax me on a concluded contract, that's an expropriation. Now, what's an expropriation? Basically, an expropriation is any sense of confiscation of property, including monies, which belong to an investor. So whether you are taxed his assets, his bank accounts, his shares, your situation is that your action is either already expropriatory or likely to be expropriatory, right? Now, in the context of this situation, one point which typically comes up is, in some of our earlier treaties, we did not have a specific exclusion for taxation. However, in the model law of 2016, we talked of an exclusion. And we have one odd BIPA, for example, Brazil, where we actually have said no dispute settlement also. Now, the argumentation which typically comes up is that if in your 2003 model law, and therefore in that era, all of the BIPAs you entered into didn't have a tax exclusion, and you only seek to bring that in 16, then in a way, by action, do you not admit that that was already something which was capable of a BIPA earlier, because the exclusion is only sought from 16. Obviously, India's argument to that is to say no, that was already inherent. It was always inherent that you could not bring a dispute on taxation. I have only made explicit what was already implicit. And this is the jurisdictional issue that we are fighting in the context of every BIPA, right? The question for us really is, what does this say about India's approach? If you see the Indian approach, the one situation is we are very hotly contesting the factor that tax should not be capable of arbitration in BIPA. We then go on to say specifically exclude tax from BIPA. That's our desire. We've also done two other things. The universal standard for protection would have been to say that I should have fair and equitable treatment. What is fair and equitable treatment? Basically, when I talk of fair and equitable treatment, I should get treatment which is in a way synchronistic with minimum standards of treatment, which really means customary international law must get precedence over anything that I might do locally. That's the right you have. Now, in India's model law, we are actually saying that I don't even want to respect in a manner the factor of saying fair and equitable treatment. What I want is a different standard. And the standard I want is a different standard in the nature of what we call full protection and security. What does full protection and security mean? A, you will get due process of the law, you will get natural justice, you will get full application of mind. What we are saying is that my system is responsible enough judicially to give you a fair hearing and a fair decision. What the international community is saying is, I don't only expect a fair hearing and fair decision, I actually expect something more, which is that as far as I am concerned, I want fair and equitable treatment for my particular investments. So if we see the Indian approach is to say no arbitration. What is the other aspect of the Indian argumentation? India says that even if you see a BIPA, there is first a requirement to exhaust local remedies, which in our case could be 5, 7, if you are lucky, could be 15 if you are unlucky. And it goes back to Nidhu's point of costs of lawyers and everything else. What we are saying is exhaust your local remedy. Once you do that, approach me in a negotiation. The negotiation is supposed to last 6 months. After the 6 months of the negotiation, effectively then there is a 3-month further process. And what we are therefore saying is, firstly, no arbitration. Secondly, the process is at least 5 years, followed by 6 months of negotiation, followed by 3 months of draft notice, etc. So what India is saying is A, no BIPA for tax at all. B, if you want a BIPA for tax 5 years and 9 months before you get there, the only way that you can cut through that is effectively to sign what is called the futility clause. The futility clause is Indian courts are incapable of dealing with the issue which I am raising. And if Indian courts are incapable of dealing with that issue, necessarily the only option is that I must go into the BIPA. And obviously, whether it's Vodafone, whether it's KN, whether it's Antrich, that has been successfully argued to say that in the context of this, you can say that there is futility in terms of relief under the Indian legal system, therefore we come into the BIPA. The bottom line here is this. What is it saying about India's desire to embrace arbitration for the purposes of taxation? And how do we as India even conduct ourselves in the 6-month negotiation period? I'm not talking in tax, but let's say there is another issue of cancellation of license. The clear message is any situation which is not mandatory, India will not accept. First, even to enter arbitration. Second, even if there is any scope to argue that there should be no arbitration, we will argue it. The sixth on the premise that India's first argument is BIPA has no jurisdiction, the foreigner is saying this is the only forum. Now, what is this really telling us in terms of where we stand in the global system? And who are we as an investment destination? Because if we say that under BIPA I will not recognize arbitration, if we say that in every multilateral forum I will again not accept arbitration, the sovereignty concept is A, I can legislate, B, I can administer, 3, I can interpret, 4th, I can judge, 5th, I can enforce, and all of this is only under my domestic law, because my concept of sovereignty includes all 5 concepts. Then what we are really telling the world is, if you invest in India, save and accept an Indian tax litigation, I as government do not accept any other forum or basis to be able to participate. Now, within all of this, what are the international judges saying? The international judges are saying there has to be a prevarication towards arbitration. Now, even in the Vodafone situation, all of you are aware, Vodafone brought one BIPA from Netherlands, another BIPA from UK, went to the High Court. In the first instance, High Court gave a stay. In the second instance, it said 3 very important things. Firstly, it said that a commercial arbitration is completely distinct from a BIPA. The two are not similar at all. The Arbitration Conciliation Act of India applies to a commercial arbitration. It does not apply to a BIPA. Second, the argument was said that if it is a commercial arbitration, internationally, is the jurisdiction of Indian courts oust. No Indian court should be able to decide. Delhi High Court said we can effectively intervene because this is not a commercial arbitration, it's a BIPA, it's a different species of arbitration, therefore we can intervene. But it said one very important thing. While we can intervene, the way in which we exercise our jurisdiction must always lean towards ensuring the efficacy of the international arbitration. Therefore, we should not interfere to disrupt it. And even if there is a jurisdictional issue, it ought to be before the tribunal, because the tribunal can decide that issue, it ought not to be with our courts. So Indian courts are saying let's lean towards the arbitration, including BIPA. International judges are saying all these issues are arbitrable, but India is still sitting on the periphery and saying that no arbitration, whether BIPA or otherwise, because my tax in all its aspects is actually my sovereign right. Now, it's a fantastic legal debate. We will spend as a nation billions of dollars on it. Claimants will spend billions of dollars on it. But the ultimate commentary that is haunting is what is it saying about us as an investment destination? As an investment destination, if tax is contentious and is one of our big contentious issues, we are repeatedly saying, I will not take any other form, alternate form of dispute resolution. You must be in my system. And as more and more nations actually adopt an arbitration route, and India doesn't adopt an arbitration route, we actually are isolating ourselves as a inefficient and probably undesirable investment destination. And I think in all our battles, maybe that's the script that we are actually losing, that we are increasingly getting isolated in the context of major nations who attract foreign investment in terms of our continued reluctance to recognize any form of arbitration. And as this whole dispute plays out, jurisdictional, then argumentative on merits, is it fair and equitable? If it is not fair and equitable, are you actually giving what we call the full protection and security? Within that expropriation, those issues on merits will play out. Then we will come to quantification. Because in some cases, for example, Antariksh, there is a commercial arbitration and there is a PIPA arbitration. And both are running in parallel. Now, if all of these arbitrations come good, what is the quantum that India as a nation will have to pay? You can take anybody's guess. But the guess is anywhere between $9 billion to somebody says $38 billion. In our current balance of payment situation, in our current foreign exchange situation, what is it that we are going to do? Because our challenge will be, I'll challenge in an Indian court saying non-enforceable on public policy. Indian court will say public policy, very narrow interpretation, I can't interfere. If so, India has to pay. Now, if India has to pay, then what happens? Now, this is the only situation where if India chooses not to pay, then India's international assets can effectively be attached. So, for example, in case of Venezuela, when they lost a PIPA, the situation is they said we won't pay. Now, there was an order by a US court to attach the lands of all Venezuelan embassies all over the world. Now, how they would have enforced it is a different issue. But you can imagine the extent of our embarrassment if, as a nation, we choose not to pay, and what we put at risk is all Indian international assets wherever they are in the world. So, when I said that if I could choose a career today, I'd really choose a career in this space because intellectually you won't get a more complex set of issues. In terms of time frame, we are in a way going to be leaders of this jurisprudence. But what is, I think, mystifying to everyone is India's continued insistence that we are an island to ourselves. And whether that's good or bad, of course, we'll see over time.
Rohan has signaled from me that we still have time. 15 minutes. We just thought that we will get into chatting with each other because we don't have a moderator. Rohan, would you like to explain for everyone's benefit in the room the famous principles of the white industries case, because that really set the momentum. And whilst you talk about that, I think it will be useful for everyone to understand where does arbitrations such as Antariksh, which is a PIPA arbitration and not a commercial arbitration, lie, because the government has challenged the enforceability of international arbitral award in a court. And third is that there was also a debate before Vodafones and the kings of the world went for arbitration, because the Indian view was that it is that BIPA is that the tax claim cannot result in a BIPA related arbitration, and hence India challenged jurisdiction as well. Because in the morning you shared with me that this could come of a challenge even at a later stage. So I think it will be useful if you try and synchronize the white industries case. Where do we stand with respect to Delhi High Court proceedings in Antariksh BIPA arbitration case, and what happens in the Vodafone and in the Vedanta arbitration as we see the future?
Mukesh, in his inimitable style, is now placed me in a situation where I must very carefully only talk about what is publicly known vis-a-vis what might sort of otherwise be known. So let me just tread the path. White industry is very easy. So two situations. First, initiation of BIPA. The general terms taken up in the context of fair and equitable issue also taken up in terms of expropriatory, but most importantly an issue taken up in terms of national treatment. Now national treatment is actually a concept which comes to us from the WTO. And if you see WTO jurisprudence, national treatment simply stated is that you will not treat a foreign entity or investor different from how you treat your own citizens. So that is really the basis you are going to follow. Now, in the context of that particular argumentation, the situation was that there was also a concept in terms of saying that did the Indian law actually give an effective enough enforcement remedy if white industries, for example, felt that they had been wronged. Right? So the situation for us is referred to BIPA. India, of course, took up a series of challenges, including jurisdictional challenges, and the situation was that those were considered, those were repelled, and for the first time there was a award against India. In today's terms, it would seem small because it was, I think, $4.18 million. But three things got established in the context of white industry. One, BIPA is an effective mechanism to be able to seek redressal for a foreign investor. Two, for the first time we saw a full articulation, at least in the Indian context, of what you meant by fair and equitable treatment. We also for the first time saw, in a way, a articulation in the context of national treatment. One aspect which in the particular award, which was quite unusual, was that in the context of national treatment, and then there was the issue of how are we effectively going to get enforcement, and the tribunal borrowed a concept which was in the India treaty with one of the Middle Eastern countries to say that while you have national treatment in this particular India-Australia, you also have national treatment there. However, how we effectuate the relief is not to be found in India-Australia, but we do find it in the other treaty, and since the core concept is the same, we can borrow the effective measure from the other treaty. The mix of all of that really sort of got us started in terms of the whole BIPA situation. As I mentioned, we then sort of got into a series of the tax-related disputes, Vodafone, KN, etc. The effective chemistry in the context of all of those, like I have told you, claimants are effectively saying fair and equitable treatment, expropriation, and in certain sort of instances, they have taken arguments also to say that there has been an abuse of other treaty protections that they should have had. Now, both of these are, of course, directed at the factor that there was a retrospective amendment. And if there was a retrospective amendment, it will become expropriatory. Government of India has typically, as I said, set up, tribunal has no jurisdiction, this is a sovereign function, you are interfering with what is our public policy. So, this is where we are. Courts have, of course, when asked to interfere, lent in the direction of saying international arbitration in the BIPA, distinct from a commercial arbitration. We are leaning towards saying take all these issues in the arbitration. Now, India is, of course, positioning all the jurisdictional issues as preliminary issues for decision. And in a way, hoping that if those are ruled on separately, then they will effectively also take further recourse against them separately. If, however, they don't get decided upfront but are rolled into the final award, then India will reserve its challenges to the award, including on the point that there was absolutely no arbitration, that there was absolutely no jurisdiction. Let me move from that to the other matter which is mentioned, which is non-tax, which is arbitration. So you have a classical situation in terms of saying that a license was granted, in this case for certain bandwidth of satellite, effectively that license got cancelled by an act of government to say that no longer have the license. What it meant is that the business could no longer be conducted. The amount of investment which had been made, partly by Deutsche Telekom, partly by a US investor, close to $630 odd million, effectively went bad because the money was in the country, but there was no business to run. Expectedly, we had a commercial arbitration, we had a BIPA. Again, the same set of issues effectively came up. Now, as this arbitration is going on, important to see two sets of issues which have happened. One situation is India's new model law actually says that in the context of what we consider to be fair and equitable, we want a carve out for two issues. If I take a action, which action is really in the context of policy formulation, that cannot come into a paper. Two, if one of my judicial bodies decides something and that decision is allied to either public policy or public purpose, you cannot take it. Now, if you reflect the two exceptions, what are they? The first one is directed at the retrospective amendment. The second one is directed at cancellation of licenses. Because we had cancellation of licenses in Arbitration and we had cancellation of licenses in 2G, both of which have become the basis for claims. So what we are doing is, we are learning our way through this, and the exceptions we are causing are the exceptions on which we are actually getting sued. The second situation from our perspective was that in the context of this particular proceeding, various arguments were made, and I don't want to go to them in detail, but as I said, jurisdictional arguments and then arguments in the context of merits. The other situation which you see is, and this is something which again I think we need to ponder on, but the first situation was there was an award on merits. The foreign claimant succeeded in terms of the merits. Now, between the time that we are in the merits phase and as we go into the quantification phase or the quantum phase, suddenly there is a FEMA proceeding, there is an income tax proceeding, there is a service tax proceeding, there is a PMLA proceeding. All of those initiated. Now, what the international community is commenting on is, either you are in an arbitration fair and square, you win, you lose. But you can't have a situation where you say that if I lose, then the full arsenal of whatever I can do against you, through my regulatory mechanism, I will throw it at you. So we are in this quite interesting phase, I would think, where A, there is an award on merits. There is a quantum phase we are going through. I think the quantum will be quite significant, but nobody can comment on that. But while that is happening, every Indian regulatory proceeding which could be unleashed has been unleashed. And in that, again, I think, hats off to the Indian judiciary, that in that process, at least at the prima facie stage, writ courts have been willing to interfere, including on the premise that the governmental action is actually visited by a certain element of arbitrariness and a certain element of bias. So it's an interesting phase of things that we have, and we'll see how it evolves over the next few months. But again, as I said, as we participate in these, there is always this abiding sense that A, we'd rather not be participating, and ultimately we want to bring everything back to our backyard in terms of saying my sovereignty, my law, my ability to act.
Rohan, you can ask me one last question before we conclude the session, but I just wanted to add a couple of observations. This is the government side of the argument on the jurisdiction. So if you go back into the history of BIPA, BIPA started becoming popular in the 1970s internationally because advanced countries who were investing in emerging markets, and there was no concept of emerging markets in the 1970s, but advanced countries that were investing in not so developed countries, they felt that there should be some degree of protection that should be available to them. And that degree of protection was either unilaterally cancelling a license or unilaterally taking away a lease or license for a natural resource such as oil and gas production, and sometimes against rogue regimes. So, if you look at the history of investment regimes, rather BIPA's signatories, it was primarily meant for that. India also embarked on the BIPA path more aggressively after the 1991 reforms. One of the arguments that is coming from the government negotiator side is that if tax is a subject which is sovereign, and there is a retrospective tax or a new levy of tax, how does that become expropriation of investment? Obviously, in both the Vedanta case and in the Vodafone case, the International Arbitral Tribunal has gone beyond the debate by coming to the conclusion, yes, a BIPA claim can be brought out even if it is tax related. But what I'm hearing from you is that even this jurisdictional aspect can be challenged in the future as well.
I mean, certainly, you will challenge it because one of the issues always in terms of the challenge and enforcement would be whether the entirety of the arbitration itself was conducted without jurisdiction. And that as an issue will always sort of come up in the stage where either you will sort of seek your remedies from the award or at the stage of the enforcement. I think your point in terms of the history and the purpose, I think very well made. The question is, where did this typically come in? So if you see some of the leading cases, it was, for example, when certain nations nationalized all the oil assets. Because from that perspective, that nationalization really just, in a way, divested whoever was the investor and invested all those properties into the state. The parallel, I think, which is trying to be drawn is that if the issue was one of an assessment, then obviously that is extremely domestic and is sovereign. But if the issue is a retrospective amendment to get over a Supreme Court judgment with only one purpose, which is to say that even if you have accessed the legal relief, even if the legal relief has come in your favor, I now have the right through legislation to effectively negate it through retrospectivity. Whether that factor of using a legislative instrument retrospectively to get over a Supreme Court judgment, whether that and the consequence of that, in terms of whether you try to attach shares or bank accounts or effectively came through the demands, whether that as a package is expropriatory, I think becomes now central to the entirety of the debate. And I guess we'll see where we are going. But one thing is, if you could be a fly on the wall listening into those arguments, that would probably be one of the nicest pieces of legal education you would get.
Okay, we'll end the session over here, but one last point I wanted to make, it's to some extent academic. Most constitutional lawyers are still debating whether Vodafone should have challenged the virus of the retrospective amendment. We all know that it accompanied with validation clauses, so on and so forth, and it was drafted by people who are very, very accomplished in the area. But I think, Mr. Banerjee, you want to make a point on that?
Vodafone amendment is challenging Calcutta High Court.
You think there's a challenge?
In Calcutta High Court, and it is pending. It was admitted by Justice Indira Banerjee. Now she is in Supreme Court. That's what I remember.
Do you anticipate the Calcutta High Court will overturn the retrospective amendment?
I don't know, but that's pending.
I think that's really about it.
I just wondered whether we could get a quick comment from Justice Karman if you want to make on arbitration.
You always managed to put me on the spot. I only heard the very end of your comments on arbitration, and I must say I found them very interesting. In Australia, we have traditionally, the ATO has traditionally not favoured arbitration, and indeed have done their utmost to avoid any form of alternative dispute resolution. They, by and large, try to enforce their maximum powers as much as they can. But I think that the way that international community is developing over the years is in arbitration. It's essential. And certainly our courts, the Federal Court and the High Court of Australia, have accepted and enforced the awards that have been made by arbitration. Not yet in tax, but I think in tax it must happen as well, because more and more we're seeing focus upon international issues coming up, where the courts, if I may say so, are not well equipped to understand the complexity of the issues and the interrelationship between the issues. And arbitration, I think, is the way of the future, with the courts supporting them.
Honourable, you should actually read the white industry decision, because it is in the context of India-Australia, which is really the landmark decision that my colleague was referring to. Thank you.